Chapter X of the Judgment or Decree. As Son 168. The judgment conclusive. The form of the judgment or decree in suits to annul fraudulent transfers, or to reach equitable assets, and the rights secured by the adjudication constitute important branches of our subject. The usual attributes attached to the judgment in this class of cases. It is regarded as an estoppel upon the parties as to the subject matter investigated, but the estoppel has no wider effect. Raymond v. Richmond is an illustration of our meaning. There the action was instituted by an assignee against a sheriff and an execution creditor for levying upon property which had theretofore been adjudged to belong to the assignee, in an action to which the assignee, the assignor, and the execution defendant were parties. The court very properly held that as the creditor, under whose judgment and execution the seizure had been effected, was not a party to the prior litigation, the adjudication did not conclude him. Hence such creditor was entitled to show that the transfer made by the execution defendant, although the title had been adjudged to be in the assignee, was fraudulent in fact, and the seizure of the property by the creditor therefore justifiable. Manifestly a purchaser of a chattel mortgage is not concluded by a subsequent adjudication in an action against the mortgagor and mortgagee to which he was not a party, declaring the mortgage to be fraudulent, and a decree between husband and wife, establishing in the wife's favor a resulting trust in the husband's lands, is not conclusive upon the husband's existing creditors. As Son 169. Judgment res adjudicata though the form of procedure be changed, where creditors seek by bill in equity to subject a vestive estate and remainder to their claims, and the courts decide against them. The question will be res adjudicata if the creditors afterward try to levy by execution on the same interest, when it has become an estate in possession by the death of the life tenant. As Son 170. Judgment appointing receiver. The particular form of a decree in a creditor's action to cancel a fraudulent conveyances, in some instances, of vital importance to the complainant. A court of equity undoubtedly possesses the power to pronounce a judgment annulling and clearing away the fraudulent obstruction, and then, by acting upon the person of the debtor, to compel him to convey the title to a receiver. The practitioner, however, should be cautious about entering up such a judgment, as the title which the receiver or a purchaser from him acquires rests upon the debtor's own conveyance, and has no relation to the original judgment which is the foundation of the bill in equity. It has been intimated that when the creditor pursues this course he abandons the lien of his judgment and seeks satisfaction of his debt out of the debtor's property generally. In Chaddock County Bank v. Risley, the creditor's action was founded upon the first judgment recovered against the debtor, and the property was, under the order of the court, conveyed by the debtor to a receiver. It was decided that another creditor, whose judgment was subsequent to that which was the foundation of the creditor's bill, but which was entered prior to the time the bill was filed, might sell the real estate on execution, and the purchaser at such sale would acquire a better title than the grantee from the receiver. The creditor should therefore be careful not to sacrifice the advantage which the prior judgment gives him, and, having cleared the fraudulent conveyance out of the way, should, especially if subsequent judgments have been entered, proceed by execution and sale on his first judgment. In Cole v. Tyler, the judgment set aside the conveyance and merely directed that the receiver should sell, execute deeds, etc. It is not easy to discover the theory upon which the receiver could be said to have acquired the title. The improper form of the judgment was assigned as a ground for its reversal, but the court said that if the direction to sell, etc. was erroneous, the error would not be rectified by an appeal, but the correct procedure was by motion to correct the judgment, the matter being one merely of detail, and not affecting the decision upon its merits. As Son 171. Judgment avoids sale only as to creditor. Not absolutely. The principle must always be kept in view, that a fraudulent sale is good between the parties. Giving effect to this doctrine generally controls the form of the judgment in a creditor's action. Besson or v. Gilmore, the conveyance was found to be voidable as against the creditor, but the court decided that the only judgment to which the complainant was entitled was a decree for the sale of the lot in suit and the payment of the amount of the claim with interest and costs, the sale being valid between the debtor and the fraudulent vendee. There was nothing to warrant a judgment declaring it null and void as to everyone. In the case cited, the judgment which was held by the higher court to be erroneous declared that the property belonged to the debtor. This was manifestly wrong, for where it does not appear that there are other creditors, the judgment, whether it directs a sale on execution by the sheriff or by a receiver, should only declare the conveyance void as to the plaintiff's judgment, and direct a sale for the payment of that alone. The grantee is entitled to all that might remain of the proceeds in the shape of surplus. And, when the creditor is paid, the decree canceling the conveyance is satisfied. The action of chancery, said Nelson, J., upon the fraudulent grantor or assignee, is only to the extent of supplying a remedy to the suitor creditor. As to all other parties, the assignment remains as if no proceedings had been taken. Under the Civil Code in Louisiana, if the action is successful, the judgment is that the conveyance be avoided as to its effect on the complaining creditors. SS 172. Judgment transferring title. The court has no power to effect a transfer of title to land by ordering a sale of it, except in special cases authorized by statute, such as mortgage and partition sales, sales of infants' lands, ordinary execution sales, and the like, and suits brought to reach lands conveyed with intent to defraud creditors. The proper decree, in New York at least, is to set aside the fraudulent conveyance and permit the creditor to issue an execution and sell under it, or compel the debtor to convey to a receiver and direct the latter to sell. It was said by Gilbert, J., in Van Wyck v. Baker, that the fraudulent deed being annulled, the title remains in the debtor and can be passed only by her deed. If, however, the receiver is directed to sell without obtaining a prior conveyance from the debtor, the erroneous judgment is not, as we have seen, to be rectified by an appeal from the judgment, but a motion should be made to correct it, where an execution purchaser seeks to cancel a cloud on his title. Of course, no conveyance is requisite, as the plaintiff will be left in the full enjoyment of the title acquired by the sheriff's deed. SS 173. No judgment in favor of unrepresented parties. In a case before the Supreme Court of California, it was said to be an anomaly in practice to render judgment in favor of a party who was not before the court and was not represented in any manner in the action. This observation was made in an action brought by a creditor against a fraudulent grantee to set aside a conveyance made by a deceased debtor, the ground of relief assigned being that the conveyance was made to hinder and delay creditors. The representative of the deceased debtor was not a party. The court very properly decided that it was error to render a judgment declaring a trust against the fraudulent grantee and in favor of the unrepresented estate of the grantor. SS 173A. Creditor suing in place of assignee. If an assignee refuses in a proper case to institute proceedings to get possession of the assigned property, the creditors collectively, or one suing in the right of all who may join in the action, may compel the execution of the trust in equity, or cause the removal of the assignee and the appointment of another. It seems, however, that in either case a decree for a single debt would be erroneous. The decree must follow the assignment, and the fruits of a recovery must be distributed according to its terms. S. 174. Confession of judgment. A transfer of property by a person heavily indebted, made by means of a confession of judgment and sale on execution, was adjudged void in Metropolitan Bank v. Durant, upon proof that it was intended to defraud creditors, and that the purchaser had knowledge of the facts. Collusive judgments, as we have seen, are always open to the attack of creditors. A judgment entered by confession upon an insufficient statement of facts is effectual and binding between the parties, and a sale of property under it is legal and valid against all the world except existing creditors having a lien upon the property. S. 175. Impounding proceeds of a fraudulent sale. While it may be true that the money received by a fraudulent vendee from the sale of the property is not legally a debt due by the vendee to the fraudulent vendor, because the court will not assist to enforce or render effectual the fraud, yet in the intention of the parties it is a debt, and creditors may treat it as such and attach or reach it by judicial process. The beneficent and remedial provisions of the statute 13 Alis would be of little avail if a fraudulent grantee could pass the property over to a mere volunteer without notice of the fraud, and upon that ground claim that the property or its proceeds were safe from the pursuit of creditors. S. 176. Accounting by fraudulent vendee to debtor. Though a party may have intended to defraud the creditors of a debtor by taking and converting his property into cash, such intent is rendered harmless by his delivering the proceeds of the sale to the debtor or his authorized agent. If the party has accounted to the debtor for the proceeds of the property before proceedings are taken against him by the creditor, he cannot be forced to account for it over again. The creditor must show that something remains which ought to be applied on the judgment. Where a third person has in good faith received a conveyance of the property in trust for an alleged fraudulent grantee, and has subsequently conveyed it to such grantee pursuant to the trust, it has been held that such third person is not a proper defendant in a creditor's action, simply because no cause of action exists against him. the trustee under an assignment of lands which is declared fraudulent at the suit of a creditor cannot be compelled to account for the rents received and applied according to the provisions of the trust. Before the commencement of the action, SS 177, personal judgment against fraudulent vendee, the right of a judgment creditor to a personal or money judgment against a fraudulent vendee of his debtor, comes up frequently for adjudication and is discussed in many of the authorities. In the recent case of Ferguson v. Hillman in the Supreme Court of Wisconsin, the conveyances and mortgages had been adjudged fraudulent as to creditors, and knowledge of the fraud had been fastened upon the grantee. The familiar principle elsewhere discussed to the effect that a fraudulent grantee in possession of the property of the debtor cannot be protected as against the creditors of the debtor, even to the extent of the money or other consideration given for the transfer, was invoked and applied. The court observed that it seemed to follow as a necessary consequence that a fraudulent grantee could not be protected in the possession of the proceeds of such property received by him upon effecting a sale of it. The property in the hands of a fraudulent purchaser is held by him in trust for the creditors of the fraudulent vendor. And when the property is converted into money, the fund thus created is impressed with the same trust. Were the rule otherwise, the grantee might defeat the creditor's claim by fraudulently changing the character of the property. In equity, such money in the hands of the fraudulent grantee is a fund held for the benefit of the creditors of the grantor. And while such creditors may not be able to maintain an action at law for money had and received for their use, because they were never the owners of, or had title to the property which had been converted into money, yet a court of equity, having all the interested parties before it, possessed the power to direct such application of it as would be just. The court further held that if, in a proper case, equity had the power to order the fraudulent grantee to pay or apply the money received by him in satisfaction of the debt of a creditor, then the fact that it directed a personal judgment to be rendered against him for the money so received, and that the amount be collected on execution, was merely a matter of form, which did not prejudice his rights, and of which he could not complain. Fullerton v. Vile is an authority in point in this discussion. This important case, which certainly embodies features of vital interest to creditors and vendees whose good faith is questioned, seems to have been affirmed both at the general term of the Supreme Court and in the Court of Appeals of New York, without any written opinion having been given. The published report of the case was prepared by one of the counsel. The facts were briefly as follows. The defendant had taken from a debtor a conveyance of real estate, subject to a mortgage of $800, agreeing to pay $1,000 in addition. The sum of $500 was paid to the debtor in cash, and $500 by canceling a debt due from to the grantee. Before the creditor's suit was instituted, the grantee had sold the real estate to a bona fide purchaser, and realized from such sale the sum of $2,270. The court found that the conveyance was made in fraud of the grantor's creditors, and that the creditors were entitled to judgment against the fraudulent grantee for the value of the premises over and above the prior valid encumbrances. The recovery was not limited to the amount received by the fraudulent grantee on the sale, but his liability was held to extend to the value of the property fraudulently received by him, and which he had put beyond the reach of the creditors of his fraudulent grantor, subject, as already stated, to the prior valid encumbrances. The grantee must have found in this case that the way of the transgressor was hard, for he was neither allowed credit for his own debt, which constituted part of the consideration, nor for the $500 paid to his grantor in cash, as Son 178, Murtha v. Curley apparently puts this question of the creditor's right to a personal judgment against the fraudulent vendee at rest in New York. The vendee had foreclosed a fictitious chattel mortgage upon the property of the debtor, and had converted the proceeds which exceeded the creditor's claim to his own use. A money judgment was directed against the vendee for the amount of the plaintiff's claim. The court held that this did not stamp the action as being legal rather than equitable, and that the judgment was proper in form. Earl J. said, "A court of equity adapts its relief to the exigencies of the case in hand. It may restrain or compel the defendant. It may appoint a receiver or order an accounting. It may compel specific performance or order the delivery to the plaintiff of specific real or personal property. Or it may order a sum of money to be paid to the plaintiff and give him a personal judgment therefor. Where the property has been converted, there is nothing to be sold, and no occasion for a receiver and no special need to state an account." In Williamson v. Williams, the fraudulent vendee had sold the land to a bona fide purchaser, and it was said that having deprived the creditor of the property and obtained its price, he must be held responsible by reason of this fraudulent disposition of the property to the amount of the consideration received by him. The money stood for the land in his hands. As Son 179. Money judgment, when disallowed. McLean v. Carey and the New York Court of Appeals is a peculiar case in which a money judgment was denied. Plaintiff was a judgment creditor. It was proved substantially that the debtor Green sold to the other defendant certain machinery with an agreement that $12,000 of the consideration was to be paid in steam power. At a time when $9,000 remained unpaid, a settlement was effected practically on the basis of a balance of $4,000. The court avoided the settlement as being fraudulent against the creditor, and the question as to the authority to render a money judgment against the defendants was presented. The complaint, it may be observed, prayed that the settlement be set aside as fraudulent, that a receiver be appointed, and that the creditor be paid out of the monies realized by the receiver. No money judgment was demanded, and the court held that under the circumstances none was authorized, as the contract was payable in steam power and not in money. Under the practice in Illinois, it seems to be implied that a personal or money judgment is improper in an action to annul a fraudulent transfer. In Patterson v. McKinney, this objection was taken, but the court said that as the cause was to be remanded, it could be obviated by making an alternative decree providing that if the judgment was not paid within a time to be limited, the land should be sold on execution. In Dunphy v. Klein-Smith, which was a creditor's suit against a fraudulent vendee, a judgment for damages was held to be improper. The correct relief was said to be by decree for an account. SS 180. Personal judgment against wife, where property is conveyed to a wife in fraud of her husband's creditors. It seems that a judgment in personam for its value cannot be taken against the wife, nor in case of her death, against her executors. Miller, J. said, while the books of reports are full of cases in which real or personal property conveyed to the wife in fraud of the husband's creditors has been pursued and subjected to the payment of his debts after it had been identified in her hands, or in the hands of voluntary grantees or purchasers with notice, we are not aware of any well-considered case of high authority where the pursuit of the property has been abandoned, and a judgment in personam for its value taken against the wife. Certainly no such doctrine is sanctioned by the common law, and though the present suit is a bill in chancery, the decree in this case is nothing more than a judgment at law, and could as well have been maintained in a separate suit at law for the money as in this suit. And the liability of the executors of the wife to this personal judgment must depend on the same principle as if, abandoning the pursuit of the res, the assignee had brought an action at law for the money. The modifications in the law peculiar to the relationship of husband and wife with reference to their property are so many and important that it would be impracticable to attempt to formulate rules intended for general application to the subject. These Supreme Court cases certainly accomplish an unfortunate result, and probably will not be universally accepted, if, indeed, the principles they embody are not superseded in some states by the removal of the disabilities incident to coverture. In Post v. Steiger, it appeared that property had been conveyed to a wife in fraud of the husband's creditors. The wife set up as a defense the fact that she had disposed of it. The court said that she must answer for its value. An attempt was made to show that she had subsequently lost by bad bargains all the property that she had acquired by the conveyance. The proofs did not seem to sustain this view, but the court remarked that even if it had been so proved, this would not relieve her from liability, and continuing said, she held the property as trustee of her husband's creditors, and dealt with it at her peril. A fraudulent grantee cannot repel the claims of the creditors of the grantor by simply saying, I have lost, by imprudent bargains or collusive foreclosures, the property I attempted to conceal, and, therefore, I am answerable for nothing. It may be urged that this case is a dictum on the point cited. This is probably a legitimate criticism, for the court practically found that the wife still had the property, yet as an expression of opinion of a highly intelligent court pointing, as we claim, in the right direction, we regard the dictum as worthy of adoption as an absolute authority. SS 181. Judgment must conform to relief demanded. As a general rule, the judgment must harmonize with the demand for relief. In Curtis v. Fox, the plaintiff failed to establish that the conveyance by the debtor to his wife was fraudulent, and the complaint was consequently dismissed. It appeared that the wife died pending the action, and the creditor contended that the debtor defendant thereupon acquired a legal interest in her real estate, and that, instead of dismissing the complaint, a judgment should have been rendered providing for the sale of such interest. and an application of the proceeds to the satisfaction of the creditor's judgment, cases like the Bank of Utica v. the City of Utica and Cumming v. the Mayor of Brooklyn were cited, in which it was held that, where both parties agree to submit the case to the jurisdiction of Chancery, or the defendant omits to raise the objection by plea or in his answer, the court will retain jurisdiction and determine the case. Although the plaintiff may have an adequate remedy at law, but the court held that the principle of these cases had no application to the case of Curtis v. Fox above cited, because in that case Fox had no legal interest in the land, and did not acquire any until long after putting in his answer. The complaint did not allege any such interest, but sought relief solely upon the ground that the title of the wife was fraudulent as against the plaintiff, and this was the matter litigated, as the husband had no opportunity to raise the objection that a sale on execution was the proper remedy of the plaintiff. So far as the interest acquired upon the death of his wife was concerned, his silence did not waive it, as Son 182 must accord with complaint. It has been held in New York to be no ground of reversal of a judgment that the relief it extended was not prayed for in the complaint, provided it was such a decree as the plaintiff was entitled to upon the evidence, while the effect of an erroneous prayer in a complaint can ordinarily be overcome. Yet the general rule is that the allegations of the complaint must support the judgment. Thus, it was said by the Supreme Court of California that a judgment which was not supported by the pleadings was as fatally defective as one which was not sustained by the verdict or finding. The judgment must accord with and be warranted by the pleadings of the party in whose favor it is rendered. This may be true under the liberal interpretation of the statutes regulating the reformed procedure, but it is unwise for a complainant to place strong reliance upon such a rule of practice. On the contrary, the bill should shadow forth the case which the evidence is calculated to disclose, or the variance may prove fatal. Thus, where the bill impeached a deed and prayed its avoidance upon allegations of actual fraud, there is authority that, where the defendant is brought into court to answer such a charge, and so effectually repels it that the court would not be justified in holding that the averment was proved, the complainant is not at liberty to change his ground and obtain other relief based upon proof of constructive fraud, or other equities supposed to be established by the evidence, and, where a bill charges actual and intentional fraud, and the prayer for relief proceeds upon that theory, the complainant cannot, under the prayer for general relief, rely upon circumstances which make out a case for relief under a distinct head of equity, although such circumstances substantially appear in the bill, but are charged only in aid of the actual fraud alleged. SS 183, Contradictory Verdicts, in Love v. Jair, which was an action brought by a judgment creditor of the grantor against the grantor and grantee to avoid a fraudulent conveyance. A general verdict was returned against both defendants. A new trial was awarded to the grantor and denied to the grantee, and the case was continued without judgment. At a subsequent term, the cause was tried by the court as to the grantor, and a finding and judgment rendered in his favor. The court, over the objection of the grantee, rendered judgment against him upon the former verdict of the jury, setting aside the conveyance as fraudulent. On review, the judgment was very correctly held to be erroneous. Clearly, if no fraud had been practiced by the grantor, it was an absurdity to find that, as to the grantee, the conveyance was fraudulent. Both parties must necessarily be implicated in the fraud. SS 183A, New Trial. The statutes granting statutory new trials as matter of right are not applicable to suits brought to annul fraudulent conveyances.